Hello everyone, good evening. Can we hear me? Good evening, everyone. Hello, good evening. Can we hear me?
Good evening, yes, sir.
All right, thank you so much for joining. Welcome to class, everyone. I can see we are a bit scanty in the session. Please, can you kindly reach out to your group members so that we can have more people joining for the call? Thank you as you do that. Class has officially started. Welcome to week 3 of the JIIPCC Mentorship and Internship Program under Intellectual Property. Under intellectual property, and in today's class, we'll be discussing IP registration, infringement, and enforcement. My name is Dennis Williams, and I will be moderating today's session. So to quickly just run us through what we'll be doing in today's class. In today's session, um, we'll be hearing the presentations from the mentors, and after the mentors have presented, we'll hear presentations from mentees. So please, mentees, get ready for your presentation. After the mentors, after the mentees presentation, we'll take feedback from the mentors, and then after feedback from the mentors, we'll take questions and answers, and then we'll call it a day. Right. So just kindly give me a moment. Let me still try to reach out to the group to ensure that we have more people join in. Right. So yes, I'm back with us. Please, like I said, reach out to your other comments so that we can have more people join in for this session. All right, so just to quickly introduce our mentors for today, we already have one of our mentors in class, Mr. Emmanuel. Thank you so much, Mr. Emmanuel, for joining in. We are happy to have you in today's session. We are also expecting to have in today's session Mr. Max Ikombe. Sorry, let me just try to gain access to their profile. Okay, we are expecting to have Mr. Max Ikombe. We are also expecting, okay, I think we already have in the class Mr. Buluwatife. John, thank you so much, sir, for joining. Mr. Buluwatife is a distinguished legal professional serving as a managing partner at Hadu Solicitors. He obtained his from bachelor's degree in law from Olabisi Onabanjo University, Agbo Iwoyi, Ogun State, and was admitted to the Nigerian bar with a robust foundation in litigation, corporate, and commercial practice. Mr. Bolo Atife has cultivated extensive expertise in this area since the outset of his legal career and has proactive approach to legal challenges. Mr. Bolo Atife's commitment to intellectual property law is particularly notable. He completed a copyright course at Harvard Law School in 2018 and has pursued further education with several courses organized by the World Intellectual Property Organization, that is WIPO. His education is underscored by international certifications in intellectual property valuation and auditing conferred by WIPO, the Korean Intellectual Property Office, Korean Institute of Science and Technology, and Korean Invention Promotion of Science and Technology. Promotion Invention Promotion Association, sorry. Boluwatife also holds a prestigious master's degree in intellectual property from WIPO and the African Regional Intellectual Property Organization and the African University. In addition to his specialization in intellectual property, Boluwatife is an associate member of the Chartered Institute of Arbitrators, as in the United Kingdom, reflecting his proficiency in alternative dispute resolution. Well-to-fare John Sanya is a sought-after speaker and author, having presented at prominent forums including the World Intellectual Property Organization Demo Day 2023 and authored numerous publications on legal topics. Okay, sorry, I lost my train of thoughts. Leverage, leverage on their intellectual property rights in their respective industry. His leadership with the legal community is exemplified by his tenure as chairman of the Young Lawyers Forum, Nigerian Bar Association, Ibadan branch from 2022 to 2024. His tenure underscores his dedication to fostering professional growth and community engagement within the legal profession. Buluwatife has appointed chairman of the national was appointed chairman of the National Young Lawyers Forum Pro Bono Committee, with focus which focused on representing indigenous persons and advocating for law reforms, especially those that do not favor young persons in Nigeria. Boluwatife was recently recognized and awarded as one of the legal practitioners under 40 in Nigeria as a rising star by the Esquire Legal Award. Thank you so much, sir, for joining. Once again, we are happy to have you in the session. So Mr. Boluwatife is a new mentor here with us, so that's the reason why I am extensively reading out his profile. And also, last but not least, we are expecting to have Mr. Folarin Aluko, right? I'm sure Mr. Folarin Aluko may join us later in the session, and when he does, we'll be ready to receive him. So please, if you can still hear me, I want us to go ahead and begin the session. Like I said, in today's class, what we'll be doing is that we'll be taking presentations from the mentors first, and after presentations from the mentors, we'll take presentations from the mentees. Please, mentees, get ready for your presentation. We want to have both groups ready to present in class. So please, if you can reach out to your group presenters right now, do so if they are not in session. After the presentations from the mentees, we take feedback from the mentors and then questions and answer. This just to give us a run through what we'll be doing. Once again, my name is Dennis Williams and I'll be moderating today's session. So I think what we'll be doing is that we'll be going firstly, we'll be taking presentations from our mentors. So we'll be listening firstly to Mr. Buluwatife, right, saying that this is his first session with us. We'll be listening to Mr. Buluwatife firstly, then we'll move over to Mr. Emmanuel for his presentation. For our mentors, please, we both have 25 minutes, right, for our discourse into the topic. We are discussing IP registration, infringement, and enforcement. You are welcome, sirs. Mr. Boluwatife, you are welcome. We are especially happy to have you in the session. Thank you so much, sir, for joining, and we hope you're able to run us through the program today.
All right, thank you so much. Good evening. Just to
Good
be
evening.
sure that everyone can hear me.
Yes, we can hear you, sir.
All right, good. Let me try to share my screen. Okay. Uh, okay, just to be extra sure, can you all still hear me?
Yes, sir, we can hear you.
I can't. Sorry, I'm trying to navigate this. Okay, I presume you can all see the screen shared. IP registration. Okay, open, well, thank you. Is that a yes from everybody? You can see my screen, right?
Yes, sir, we can
All
see
right,
your
thank
screen.
you. Thank you so much. Please, if at any point you can't hear me anymore, please notify me because the network here is quite shaky and I can see that the internet is notifying me of this. So, good evening once again. As mentioned, my name is Boluwatife Sonia, as you can see on the screen too. I'm here to discuss IP registration, infringement, and enforcement. So what I'm going to try to do, since I've seen your agenda, is to do an overview and not necessarily go into full details. Whichever I find very important to discuss in detail, I would definitely do that. So anyone who has read any of my works would have seen this quote from me. And it is that a business that has not protected its intellectual property assets is akin to a bottle of water without lid. Yeah, so I don't know if you can see me too. I think you should be able to see me. This is a bottle of water, and the entirety of can you all see me aside from the screen I'm sharing?
From my own end, I can see you.
You can see me. Yeah, I want to believe there's usually a very small screen somewhere where you can see me aside from what is being shared. So this is a bottle of water with me. What I'm trying to say is the entirety of this is your business, the water that is in it. And please, you need to understand this at this point because going forward, I'm going to be referring to this quote back and forth. So the entirety of the water that is inside are your IP rights. Talk of copyright, talk of your trademark, talk of industrial design, talk of patent is the entirety of the water that is inside. The lid is what you use to cover it, sort of protection. So what happens if there is no lid, if there is no cover to the bottle? It simply means that if the bottle of water is standing this way, it could be breeze, it could be anything that would make it fall off. The water will spill, which simply means your IP rights will spin. Would spill, I mean. So simply means if you don't use the cover, your IP rights will not be protected. In fact, if the cover is not the registration, it simply infers that anybody can take it up and do whatever they have to do with it. So putting that in mind, again, I would say a business that has not protected its IP assets is just like a bottle of water without lid, without a cover. So let's go deeper into what I've stated, the analogy. So the bottle, as I said, the entire bottle on its own is a business. This is not too abstract. Don't worry, you get it if you're not with me yet. So this is not too abstract. The entire bottle is a business. The water that is in it, as I said, are the IP assets. Talk of your patents, your copyright, your brand, mention it. The lid, this cover on the bottle of water is the registration. That's where you use to cap it up. You use to protect the water that is in it. Now, the seal or the grip, you understand that there are some bottles of water, you barely see them now these days. That aside from this lid again, you see some type of nylon that they use to seal the water or seal liquid contents. So you could say, yes, that's enforcement. So someone opening it and drinking the water or pouring it and refilling it or whatever, that we could refer to as infringement. So let's go deeper again. Let's talk about the business, which is the entirety of the bottle. So imagine a bottle of water on a table. The bottle itself is your business structure, while it holds everything together. I'm surprised I had brought up a bottle here. Oh, just a minute. Well, I'll send the slides to the organizers of this. The view I am having here shows that you can't see the bottle of water, which is an image on this same slide. When you receive my slides, you would see what I'm talking about. But in any case, I have a bottle of water here that you can see. I can use as an example. So, as I said, the bottle on its own is sort of, as a matter of fact, let me just remove this so that you can understand me very well. So, say for instance, we have this. This is a bottle of water. There is water in it. Now, this is the business on its own. The bottle itself, the structure, the everything, this is the business. Without water, don't imagine that there is water in this. Let's just leave the water at the base. So that's the business. Now, the intellectual property in itself is the water you can see in it, the entirety of the water. What happens if you have a bottle of water without a cover? The water just being like this. It simply means it could spill, anything could happen to the water. So inside the bottle is clean drinking water. This represents your brand name, your logo, your product formula, the creative content, and all of that. That's referred to as your valuable asset. So the lid on it, oh, fortunately on this one, you can see the image. You would see the Ever water full now. You can see the lid on it. You can see the branding on it, Ever. You can see everything on it. Very perfect. So it is when you put the lid on it. So simply infers that you can have several intellectual property assets. But if you don't put the lid to registration, you are just a joker. And please note, and of course, I presume that many persons here should know that there are some IP rights that you don't need to register. Say for instance, your copyright, it is not necessary. That does not mean you cannot register. Another form of way to protect IP again is through the trade secret system. So, but there are measures you must put in place or requirements you must satisfy, which form or which we would say is the registration, the lead on it to cover the water, to protect your IP rights, which is the water. Now, place a tight lid on the bottle, and the lead is IP registration, trademark, copyright, patent. Mention it. It prevents easy access to your water. Now, without the lid, anybody can tamper with it. As I've said several times, if you don't have this lid of water on it, it simply infers that your water can be used, your IP rights can be used by almost everybody or anybody. So, enforcement. I'm sincerely not happy that this image is not here. So there's this image here. Enforcement is a tamper-proof seal. As I mentioned earlier, there's usually a nylon on each cap on the lid like this for some types of bottled water or some type of liquid. Someone watching and holding the bottle carefully. So someone is watching and ensuring. So you must protect your IP rights. How do you do that? This represents enforcement. So you monitor the market, sending warnings such as cease and desist letters, taking legal action if needed. There is not enough to have a lead. You must ensure no one breaks it. So it's not just enough that you register. You must also ensure that somehow you enforce it by protecting. So usually what I would tell my clients often is that don't wait for infringement to happen. You must protect yourself before the infringement happens. So I also look out sometimes for infringers. And how do you do that? Sometimes you look at the trademark publications and you would know those that want to infringe. So let's go next. Infringement, tampering with the bottle. Some persons, say for instance, if you want to start drinking the water and also which is your IP rights, which is sort of exploiting your IP rights, the water, opening the bottle without permission. You see people start using your IP rights without permission, drinking the water itself, using it, refilling it with inferior water and still calling it Ever water. Some persons, say for instance, start selling pirated products and they would still name them Ever water. They would still name them any other your name and they would pretend as if those are your products. You can see that you see that in some markets in Nigeria. Of course, it's not even in Nigeria alone anyway. So that is infringement such as unauthorized use of your brand, counterfeiting, copying your product or identity. Now, again, the analogy. Again, I would tell you, if you can have this at the back of your mind as an image of a bottled water, the bottle in itself is your business. The water are is your intellectual property assets. The lid is the registration. The seal or the grip that is used, whether the nylon they use on it or the grip, the seal that they use here at the cap of, you just cannot open a bottle of water that way. I mean, with a bottle of water you are taking fresh, there's usually some grips, there are some stuff that they do use to seal the lid to the cup, to the bottle itself. That's sort of an enforcement. Then someone opening or drinking or refilling your products or the bottled water is infringement. So let's go straight to or before I go into that, does anybody have any question regarding that? I understand I have limited time, but I would still be able to cover up. Does anybody have any question regarding this? I will not be able to see if you are raising your hand, so you may as well just unmute yourself and talk.
Alright, sir, we usually take questions later in the session, towards the end of the
Okay.
session. So I don't
Oh,
know,
good.
maybe they are more prepared to do that
Oh,
right
good.
now.
Good then. Good. Thank you so much. Okay, so I'll just wait till then. So let's go to IP registration. Quickly, let's talk about copyright, even though I later gave a general overview here. So copyright, what are the subject matters it protects? It protects literary and artistic works, such as music, books, photographs, etc. So what are the requirements now? Before any work can be protected, before you can say, oh, this work is protected by copyright, what are the requirements? Basically, there are two requirements. The first is originality. Your work must be original. Simply means independent creation. You must have expended efforts. And you can see the Sheldon's case. You can use Google Scholar to read Sheldon's case. Then independent creation simply means that you did not have access to another person's work before you did that. So if, for instance, you are writing a book and it's possible somebody else is writing something similar to yours. So if you are able to write yours and you did not have access to the other person's work before you published yours, yes, that's independent creation. You must have expended some effort, not that you just take a work and just do whatever and you say, oh, it's independent creation, it's original. Copyright does not protect that. So second requirement is fixation. It must be expressed in a medium that it can be reproduced. So we must be able to say, oh, okay, where is the work that was, and in copyright, we use the term work. Where is the work that was created? So you must be able to refer to the work. It must be something that can be reproduced, that can be seen again. So copyright protection is automatic, at least in Nigeria, once fixed and original. So that's also the fixation and the originality again. Registration is not necessary but advisable. Okay, I would probably at the end of today's the class today, or the session today, I would be able to share my screen to show you some copyright certificates. I saw that this morning. I was hoping to show you. So the regulatory agency for copyright is the Nigerian Copyright Commission, and presently headed in Nigeria by Dr. John Asen. Then you have to be an agent of the commission before you can register. Of course, what that simply means, not the client would have to be an agent, but yourself, who is a legal practitioner, would have to be an agent before you can, of course, register for copyright or register a work for copyright. Which law guides copyright at the moment? It's the Copyright Act of 2022. So not to take time, I did a tabular form instead of talking about each of these one by one. So that's copyright, which I've covered earlier on. So industrial design protects the appearance, shape, pattern, ornamentation of a product. It's also, the requirements principally is novelty. Then registration, of course, that's required. The regulatory agency, we have the trademarks. We have the patents and designs registry, sorry, not the trademarks. We have the patents and designs registry. Then for patents, we have inventions. Of course, we have the products, and what it protects is either the products or the process. Then for patents, we have novelty. It must be an inventive step, and it must be industrially applicable. Registration, of course, is required. And for that, we have the patents and designs registry. Please cancel that trademark on it. I will do that before I share my slides with the organizers of this session, of the entire mentorship session. So the trademark, we have the brand identity name. The brand identity protects that the name, logo, slogan. And until recently, I've always argued, and several persons have agreed with me, that the trademark also protects smell. It protects smell, it protects sounds. We call it non-traditional marks. So all of these name, logo, slogan are referred to as traditional marks, but you would observe that there are some marks, there are some smells that you find very distinctive. And the argument has been that if something, whether it's a smell, a sound, if it can distinguish one product from the other or one service from the other, to my mind and to the mind of some other scholars would say yes, that passes for trademark. Since the essence of a trademark is distinctiveness, is to distinguish one product or service from the other. So if your smell, if your mark, and that's why you should have a name or logo or whatever, if it can distinguish your product or your service from that of a competitor, that serves as a trademark. Registration, of course, is required. Then the regulatory agency in Nigeria is the Trademarks Registry. That's headed by Dr. Yaogi. So let's talk about infringement. We've talked about registration, which is the first thing. Registration is the lead, the cover of the water, of the bottled water. So let's talk about infringements now. Oh, you've registered. Let's see how someone wants to infringe. So what's infringement basically? Infringement is the interference with any of the exclusive rights granted under an IP law. So when you register, say for instance, any form of copyright, when I mean any form, probably you have a book, you have a movie, or you have whatever, which is protected by copyright. There are usually exclusive rights that are granted by such registration, or for copyright you don't need to register, not necessarily, but it doesn't even say you register. Whether you register or you don't register, but there are some rights that are conferred on you, exclusive rights. Such exclusive rights would mean, say for instance, one, the right of reproduction. So once anybody reproduces your work, it simply infers that that person has infringed on your work. Look at all types of IP generally. The moment on the exclusive rights, the moment anybody does or interferes with any of those exclusive rights, just put at the back of your mind that that is an infringement. So these rights belong to the owner or registered holder of the IP. It occurs when a third party uses, copies, or exploits the IP without permission. Using what is not yours without authorization is infringement. So copyright infringement. I just spoke about this briefly. Copyright protects creative works such as movies, books, and photographs, etc. too. Infringement occurs when someone violates such rights, right to reproduction, distribution, making available to the public, and all of that. So for instance, uploading someone else's movie online without permission, this infringes the owner's rights to reproduce the work, make it available to the public. I want to believe everybody attending this session recently heard of the arrest of forgotten his name now, but the CEO of Net Niger. The CEO of Net Niger was recently arrested because he has uploaded
Melissa, can you hear us? Your sound went off.
yes, can you hear me now?
Yes, we can hear you now.
Apologies, that's electricity, but I presume I should be able to go on. So can you still hear me?
Yes, we can still hear you.
Okay. Um, so yeah, so I stopped at the arrest of Net Niger, the CEO of Net Niger, and what they simply did was that is even digital infringement, and which is the most type of infringement we would see these days, where so the infringement happens often now on the internet, and not even the old times when you see NCC gets police to help them go to Alaba market or go to whichever markets or go to Onitsha or go to wherever to go and arrest persons who are um, reproducing pirated reproducing movies, of course, which are pirated copies, and selling them to the public. Now, the issues we are having is, say for instance, Funke Akindele, Tony Abraham, and a lot of these guys, they shoot movies with a lot of millions, and what they find out later on is within days or within hours, they see that the movies are on YouTube, or you can find the movie on Telegram or on wherever, or those that don't even shoot their movies in cinema, those that don't place their movies in cinema or Netflix, they find out that those that are on YouTube, there are some producers in Nigeria now that basically they do YouTube movies. They find out that the moment they upload their movies on YouTube, before they know it, some other guy has already uploaded the same movie on his own YouTube too, gaining a lot of traction. So these are issues, that's copyright infringement, and basically these are the extant issues we are facing in the industry. So patent infringement occurs when someone makes or commercially uses or sells or imports a patented invention without the consent of the patent holder. Industrial design and trademark. Industrial design is unauthorized use or not authorized copying or imitation of a registered design. So you understand that industrial design is the aesthetics of a product. Say for instance, let's talk about cars now, automobiles. Hyundai Sonata, Hyundai generally, they have some sort of very good shape. Look at Benz, look at BMW, they all have very distinctive shapes. Then those are actually industrial designs. Then trademark infringement, use of a mark that is identical or confusingly similar, used in same line of business. So you guys are in the same line of business, but you are doing the same thing. In fact, recently I was in a board meeting and the bottled water that was given it looked so similar to that of Seaway. I don't know if anybody here has come across the kind of bottled Seaway water is. But then I looked very well. It was not Seaway, it was a different company. In fact, I had to take pictures of that bottle of water just to be sure. That on its own is an industrial design because the bottle in its own looks like that of Seaway. So let's go to trademark infringement using a name or a mark that is similar to that of your competitor. And of course, you guys are in the same line of business. So, IP enforcement. I'm trying to run through this so that other mentors that are here would be able to talk. And I know mentees too are supposed to also present IP enforcement. So, enforcement is the act or process of compelling compliance with a law, mandate, command, decree, or agreement. In IP, enforcement aims at safeguarding compliance with the various IPRs, intellectual property rights, granted by a given legal system. Now, there are the procedures and the remedies given by a law to address infringement of IPRs. So IPRs can be enforced broadly in two ways. Please note, intellectual property rights can be enforced broadly in two ways. It can either be civil and it can be criminal. So, and you recall I mentioned some minutes ago that the CEO of NetNiger was arrested by NCC and was charged to court. So that's the criminal aspect of it. Now I'm looking forward to see several suits that will come out of that. And what do I mean? I'm hoping to see several producers who NetNiger has uploaded their movies on his platform or on his website who would take out civil action. And of course, if you look at all the acts of the National Assembly talking about the Patent and Designs Act, the Trademarks Act, the Copyright Act of 2022, you see that those acts say that you can run concurrently, both the criminal and the civil action. So enforcement mechanism will be determined based on the nature of infringement, type of IPR infringed upon, and strategy of counsel. Say, for instance, for me, I usually ask my clients a question. What do you want? Is it your money that you want? Do you want compensation? Or you want to just punish this person? Or you want to do both? So it really depends on the strategy of counsel, the type of intellectual property rights infringed upon, and the nature of infringement. Of course, it may be digital, it may be, in fact, recently we tried also doing some form of criminal enforcement for some digital infringers, and although the NCC has not been doing so well in that regard, but then we are a bit elated with the arrest of the CEO of NetNiger. So I just mentioned that so you
Hello, Mr. Emmanuel. Mr. Bulwatife, sorry. Are you with us, sir? Your network has gone off. Hello, sir, can you hear us, sir? Okay. Sincere apologies. I think our mentor is experiencing some challenges at the moment, and we'll just give him maybe a minute or two to rejoin back. Okay. Hello, sir. Can you hear us now, sir?
Yes, apologies. I didn't even know that I was no longer speaking to everyone. Why did I stop, please? What did you hear?
Okay, so the last thing I heard was you were at least talking about some of the civil matters, how what's just to paraphrase, you were just discussing based off of enforcement, court matters, what kind of piracy, visa piracy, you were talking about within that line, type of enforcement, visa piracy, you were discussing advising your clients and what kind of step they would want like to take when pursuing um, a case, whether if it's their money they would like to get back or or whether if they want to punish the person. You were reading that line.
Okay, okay. Thank you so much. My sincere apologies for for this back and forth, that's because of my internet and of course the electricity. So let me just take it up from types of IPLs, types of ways you can enforce. You can enforce that by civil or criminal. And as I was mentioning, that it also would depend on strategy of counsel, on which of the ways you want to adopt. I had mentioned earlier that uh, I usually would ask clients, do you want to get your money back and compensation, or you would just want to punish this person, or you even want the entire thing together? So it's important that we know, and also the type of intellectual property rights that is infringed upon will determine your strategy. So let's talk about criminal. Let's start from copyright. The copyright, we have sections 44 to 46 of the Nigerian Copyright Act 2022. I would recommend that you please go through those sections. Particularly, let's look at section 47 confirms that both civil and criminal measures can be taken simultaneously. I mentioned that earlier on, that you can both take out a criminal action and a civil action against an infringer. And this is done by initiating a petition to the Director General of the Nigerian Copyright Commission. So what should be the content of that petition that you'll be writing to the DG of the NCC? So the first is that you must establish ownership of the work infringed. So you must establish that, oh, okay, so what do you establish that? You need to establish date back, look at the originality and fixation. This person, my client, was the one that we made this work on so date. If he has registration particulars, you cite and you attach such certificates, and then you attach the work in itself. You also talk about the year of creation and details of the person who infringed, so that they would know who they are going after. So let's go to trademark infringement. So if we look at the Merchandise Act, Marks Act, Counterfeit and Fake Drugs and Unwholesome Processed Foods Miscellaneous Provisions Act, and the Cyber Crimes Prohibition and Prevention Act 2015, they both provide for criminal liabilities and consequences for trademark infringement in Nigeria. Now let's look at the Merchandise Act criminalizes trademark and trademark description-related offenses such as forgery of trademarks, false application to goods of any trademark or any mark so nearly resembling a trademark as to cause deception. So a person who is convicted of an offense provided for in the Merchandise Marks Act is liable to imprisonment for 6 months and a fine. However, if a person is convicted by virtue of the proceedings before the Federal High Court, the offender is liable to imprisonment for 2 years or a fine or both. Now, the Counterfeit and Fake Drugs and Unwholesome Processed Foods Miscellaneous Provisions Act prohibits the sale, distribution, importation, and possession of counterfeit, adulterated, or fake drugs and unwholesome processed food. Any person convicted is liable to a fine not exceeding 500,000 naira, a term of imprisonment of not less than 5 years or more than 15 years, or both a fine and imprisonment. Honestly, this provision has not been implemented. So a person is also prohibited from intentionally making use of a trademark on the internet or any other computer network without authority or rights and for the purpose of interfering with the use by the owner. The person shall upon conviction be liable to imprisonment for a term of not more than 2 years or a fine of 5 million naira or both. So you would note that that is infringement in the digital space. So in criminal proceedings, the copyright owner must prove the actor's serious, of course, and menswear. I want to believe everyone here has gone through criminal law or criminal litigation. That infringer knew he was dealing with an infringing work when, of course, he was doing that. You may see the Nigerian Copyright Commission against Edolo. It's 2008 2011 6 intellectual property law reports. So let's talk about civil. I've covered criminal. Let's talk about civil now. The civil strategy of enforcing infringement of intellectual property rights is broadly referred to as dispute resolution. So you could say dispute resolution could be broken down into two again. You could say litigation and, of course, alternative dispute resolution. So litigation is approaching the court. Alternative dispute resolution is mediation, arbitration, or negotiation. So how does litigation, how does that play out? This is the resolution of dispute through the courts. Now, the court that has jurisdiction for IP disputes generally is the Federal High Court. You cannot, no court in Nigeria has jurisdiction for IP disputes generally. So look at section 251 sub 1F of the Constitution of the Federal Republic of Nigeria 1999 as amended. So it's granted exclusively to exclusive jurisdiction to the Federal High Court. The provision here is provided. So Section 46 of the Copyright Act also provides for jurisdiction. If you look at Section 67 of the Trademarks Act, also does same. Then also Section 32 of the Nigerian Patents and Designs Act also defines courts to mean the Federal High Court, which simply means if you look at generally IP disputes, it's the Federal High Court that has jurisdiction for such matters. Then our actions commenced, in litigation. For civil, it's commenced. Don't forget, I said for criminal, you would have to do out that through a petition to the necessary regulatory agency, which I've mentioned earlier. Then for civil, how do you commence that? You may have written a cease and desist letter or a demand letter to the infringer. Please note that it's not in all instances that you write a cease and desist letter to an infringer. Say, for instance, you know that someone is making pirated copies of your work, and you now carry your system and you start typing cease and desist, making pirated whatever. It doesn't make any sense. What would rather make sense is to get an injunction from the court and for you to approach the court to go and get, of course, you need to first file a substantive action by a writ of summons. Then you get an injunction from the court for you to go with the law enforcement agents to evade the person's premises, get at least substantial part of those products so that you could establish. In that instance, if you write, and that's why I said it depends on strategy of counsel. If you write a cease and desist letter to such person, you just observe that the next day the persons are no longer there. So it's not in all instances that you commence such action with a cease and desist letter. So this body where you're supposed to file a writ of summons and it's to be accompanied by a statement of claim and the other documents I've stated here. So what are the remedies you claim in the statement, in the writ of summons, and of course in the statement of claim? You ask for damages, monetary compensation to restore the loss. It could be general or specific damages, or it could even be both. So specific damages must be proven specifically. So you must be able to prove that, oh, okay, this is what I've lost when this person infringed upon my work, and this is the specific amount I've lost. Court asks that this person pays me this amount, X amount, for what he has done or she has done. So account for profit. This relief is granted as an alternative to damages. So you cannot be saying you are claiming for damages and you're also saying that account for profits. So the plaintiff cannot be compensated twice. The aim of this relief is to get the entire sum illegally made through exploring the owner's work. In cases of innocent infringement, this relief is more appropriate. So if somebody infringes innocently, it is better you say, oh, account for profits. Injunction at superior order is also another remedy. Expunging mark from the trademark register. As when the mark has been registered already, you can ask the court to direct the trademarks registrar to expunge the mark from the trademark register. So then criminal imposition of fine, it could be restitution, it could be imprisonment. I wanted to mention something we are doing at the moment in digital space, but if I still have the time before the end, I would do that. Then defenses. Okay, so if, for instance, you are defending someone who has been sued for infringement, what could be your defenses? So copyright. Note generally, when you ask for defenses, when you want to defend an action such as this, you should first avert your mind to the defenses that is available in the act. Just think, what are the exceptions? So the work in question is not copyrightable. You could say, I've looked at the work, it's not original. No, you did not expend time. You could raise that argument that it's not original in the first place. So if something is not original, then you cannot say it's protected by copyright. Secondly, you could say, oh, it is not fixed now. It's not in it, but for you to say that argument may not fly, because for you to say it is not fixed, it implies that where did you even get yours in the first place? So, and it simply implies that you will not be able to establish fixation. So innocent infringer. This is sort of not a defense, but at least it would reduce the sledgehammer that will be slammed on your client. So the appropriate remedy would then be account for profit, as I mentioned earlier, and not damages. So fair dealing. Fair dealing could be parody, educational use, public interest, if you have used the work for any of all of those. And it could also be compulsory license by the government that was granted, or even by the court. So patents, it is not patentable. You could say it does not satisfy the requirements of patentability. You could say it is not for you didn't use it for commercial purpose in the first place, the product or the process. Then you could say compulsory license. You could say estupel. Estupel simply means that the patent holder, either by express or implied representation, left to his knowledge, left the infringer to continue with the act or that he would not enforce his rights or has no rights at all. So if, for instance, now you know someone is infringing on your work and you are looking afar, the first year is passing, the second year is passing, and you can establish that yes, the patent owner is aware, or the patent holder is aware that yes, he's aware that you are infringing and he kept quiet about it. That could be that he has waived off his right by estoppel. So trademark, you could say it is invalid in the sense that it is not even distinctive in the first place, or it's there are some issues with it, such as, say, for instance, it's part of the prohibited marks. I hope you know that there are some marks that are prohibited. So there's no likelihood of deception. You could say, oh no, the ordinary man who is in this industry, the ordinary consumer who is in this industry cannot mistake your product for my product. That's also a defense. Then right of independent use, then registration in different classes. You could say, oh, you registered yours in class 1, I registered mine in class 10. So of course the products in those classes differ. So let's talk about alternative dispute resolution. You could use arbitration. It could be a clause in a contract between the parties or based on agreement of parties when dispute arises. Decision is binding, of course, we know that. The mediation in neutral intermediary assists parties to resolve the dispute. Decision is not binding unless parties want it binding. So you could also look out for the WIPO ADR mechanism. That's recommended. And also, I should just mention, you could also want to join the WIPO ADR Young Member Group. I think maybe I would share that with you after this, but you could just run it on Google, WIPO ADR Young Member. Funny, some persons here may even be members, so that you could also follow up with programs that they organize. The WIPO domain name dispute resolution. So you organize, how many minutes more do I have?
So you have like 3 minutes left, sir.
2 minutes. Okay, thank you so much. Okay, so WIPO domain name dispute resolution. I'll just skip this. Then these are provisions in the TRIPS agreement. Yeah, I'm done already. So the laws that you should look out for: the Trademarks Act, the PDA, Patents and Designs Act, the Merchandise Marks Act, Copyright Act, and a whole lot of the acts that you can see. These are the references. Thank you so much for your time. I will share my slides with the organizers of the event. Thank you so much.
Thank you so much, Mr. Bulwatipe, for running us through your presentation. It was very detailed, easy to understand, and as straight to the point as possible. So thank you so much, sir. We really, really did enjoy your discourse. We really did enjoy your discourse. For the mentees, once Mr. Bulwatipe forwards his presentation towards you, you'll be getting it in your group. So please look out for that. We have Mr. Emmanuel on the call. Thank you so much, Mr. Emmanuel, for your presence. We really sincerely do appreciate you being here too. Please, sir, we want to also give you the floor also to share your thoughts with us, while we encourage the mentees to pay attention to everything our mentors have been saying and will be saying, and also please try as much as possible to get ready for your presentation after Mr. Emmanuel is done. So, Mr. Emmanuel, so over to you. The floor is yours. We want to hear what you have prepared for us in today's session as regards IP registration, infringement, and enforcement. Welcome, sir.
Okay, good evening, everyone. Can you all hear me? If you can hear me, just indicate so you can hear me.
Yes, sir, we can hear you. Good evening, sir.
Oh, okay. Thank you very much. I shared a slide earlier, but because of the timing, what I will do is I will just start by, I know the topic we're speaking on this evening is on IP registration, infringement, and enforcement. I would like to start with posing a question, and basically today I will just dwell on two scenarios, and I feel that from that particular two scenarios we'll be able to appreciate what truly IP infringement, registration, and enforcement is all about. So my first scenario, I don't know if you have my slide, or I should just put a question on the chat box so it will be easy for us to follow. So I will
Okay, so I have your
I will
slide,
just
sir. I will
quickly put a
just
question on the chat box. Okay, you can share, you can project the slides. So pending when you project the slide. So I want to just quickly share this scenario. So that's the first scenario. I just posted a question on the chat box. If you can see the particular question, the icebreaker one, the Vera song problem. So a small town artist. Can you still hear me? If you can hear me, please indicate and say you can hear me. Hello?
Yes, sir, we can hear you, sir.
Okay. So it
I don't know if I'm the only one, but I can't seem to hear Mr. Emmanuel. Mr. Emmanuel, are you with us, sir? Can you hear us?
as infringements actually occur.
Hello, Mr. Emmanuel. Can you hear us now? Your voice was breaking. I don't know if it was just from my end, but you were not very audible. Can anyone hear me? Or is it just me having that network issues? Please, can someone confirm that they can hear me?
I can hear you actually.
Oh, okay, so I think it's Mr. Emmanuel's network. Please, we'll just kindly give him a few minutes to resolve his issues. Please, once again, the mentees, please get ready for your presentation once Mr. Emmanuel is done. If your presenter is not on the call, please make sure to get your presenter on the call. We want to hear your presentation. So please, let's kindly make sure to do that.
Calling now. I'm audible enough.
Yes, we can hear you now, sir. Welcome back.
I've removed and placed the mic. Can you hear me now? Is it better? Hello?
Yes, we can hear you. We can hear you, sir. It's better.
So is this better now? So I'm not using an earpod, so I'm just speaking directly to the phone. So if it's better. So I said I will be starting with an icebreaker. And the first question with respect to the icebreaker will help us understand better because with respect to talking about infringement over time. So I said a small time artist. Now I'm giving the scenario upon which I will now ask a question. A small town artist records a song in his room and uploads it online. A bigger artist discovers it, recreates the song with better production, and releases it. The new version goes viral. millions. The original, that's my song. Now, the question that I'm posing to us and which I want us to try and answer meant actually I. And the third is who is entitled, is tied to IP registration and so I'll start with the first, and if you as infringement actually occurred. So can sound or style be legally owned? And three, artists or the big artists that discover the song creates the sound with better production and releases it. Please, I'll give us some few seconds. If you want to attempt, please just indicate or drop your answer on the chat box. Okay, so that's scenario number one. Just to give us a conversation in your mind. So my first answer is related to as infringement actually occurred. This is how I perceive it. And for my position,
Sorry to interject, but your network is still kind of breaking. Mr. Emmanuel, are you with us? Sorry to interject. Hello, sir. Hello, Mr. Emmanuel, are you with us, sir? Your network is very bad. It's really, really breaking. So maybe you can turn off your video so that it may help with the quality of
okay.
your audio.
So have you been able
Yes, we
to?
can hear you now, sir.
Okay, so with respect to the first question, has infringement actually occurred? So my answer is not automatically, and this is where many people get it wrong. Copyright laws protect original expression, not idea. So the key question for me is, did the bigger artist copy a substantial identifiable part of the original song? If what was taken includes melody, lyrics, chord progression with distinct arrangement, or a recognizable hook, then infringement is likely. However, if the bigger artist only recreated the vibe, production style, tempo, or general sound artistic, then it is unlikely to amount to infringement. Now, court typically requires proof of access, substantial similarities, not just it feels like my song. We must understand that. I don't know how many of you have seen This is Nigeria and This is America, and some of the defense that came about with respect to that particular production. Most of us would have seen it. And in recent time, you would have equally seen some similarities with respect to some music level similarities, but that does not automatically make it an infringement. For it to be an infringement, you must be able to talk about what substantial part of that particular song was taken. Is it the melody? Is it the lyrics? Is it the recognizable hooks, the chord progressions that were taken? Or was it just the vibe or production style? That's not enough to say it is an infringement. Now, the two would be, could sand or style be legally owned? And my answer is, very short answer is no. Style is not protected. That this is my style and all of that. No, you cannot monopolize a generic, maybe Afrobeat or trap, a vocal delivery style, or a production technique, or a general feel, and say, oh, because I usually feel like this, anybody that feels that way, then that is my style. No, style is generally not protected. Now, the Prince's principle is referred to or is reinforced globally, even in high-profile disputes where artists claim that their sounds were copied. However, there's a subtle exception. And now, what is the exception? If the sound includes unique fixed elements, e.g., phrases, then that specific expression can be protected. So style free for all, but specific expression is protectable. So if there are specific expression that makes a particular sound distinct, with then that is protectable with respect to the copyright boss, because I know and I noticed that the network is a bit breaking, just to help us to follow. So I will just do that on the chat box. Now, these are just what I feel is the answer. We might have someone else that he also might want to take it from a different perspective. But me looking at it, this is how I feel the answer is. Now, for the third question, who is entitled was actually copied. If infringement is proven, the original artist may be entitled to damages, royalties, or even a share of publishing rights. If no infringement, the bigger artist keeps everything, even if morally questionable. This is where law and ethics diverge sharply. The law rewards originality, not influence or inspiration. So if you say because you have an inspiration, but that's not what the law rewards. It is originality that is being rewarded. It is originality. So for purpose of ease, I will equally type this on the chat box so it's easy. So it's easy for us to follow. Okay. Can you still follow me? And if you can still hear me, please indicate and say me, so I'll know that you're following.
Yes, sir, we can hear you. Hello, sir. We can. Your voice is still breaking a
Can
bit.
you hear me?
Your voice is really breaking, sir. Now,
Can you hear me?
yes, a bit. Hello, sir. Can you hear us? Okay, Mr. Emmanuel's network seems to be breaking badly, like very bad. I don't know if he can still hear us. I really don't know how we would go about this challenge with network. Mr. Emmanuel, are you with us, sir? Hello, Mr. Emmanuel. Uh, so what we are going to do is, if maybe in the next 2 or 3 minutes, Mr. Emmanuel is not back with us, we may go back to taking presentations, and then once he's able to join us, we'll continue with his discourse. So maybe if after a minute we don't have Mr. Emmanuel back with us, we will just move on to presentation. So please, group presenters, get ready, and then we'll try to see how we can communicate with Mr. Emmanuel to have him back and join us to continue his discussion. All right, so okay, Mr. Emmanuel is not back, so we'll be taking presentations for now. Please, group presenters for group one and group two. Hope you guys are ready. We are ready for your presentation. So group one, presenter for group one, if you can kindly share your slides and start your presentation. You have 10 minutes. Please let our 10 minutes be 10 minutes. Let's try to get our presentation done within the stipulated time frame. So group presenter for group one, if you're ready, please kindly turn on your, share your slides and start your presentation. Group one, are we with us? Okay. While group one is getting ready, please can we take group two's presentation? So your voice isn't so clear, but we can hear you.
You guys, if there's any background noise, I have to be in church. Okay, let me
Okay.
show our slides quickly.
All right, please go ahead. We can partly hear you, so please continue. Go ahead, share your slides and let's continue.
You can see it already.
Yes, we can see your screen. Please go ahead.
So,
Can you try to put your screen on landscape so that we can see your full screen better?
okay, fair enough.
Yes, this is fine. We can see your screen. Please go ahead.
Okay. So my name is Sylvia John Adam, and I am the presenter for this week for grade 2. I will try my best to stick to my slides and not look at it because I'm going to the topic and it's a very, very interesting one. Then one of our mentors has already done a lot of justice to that. So I'm wondering what I'm going to come and say, but I will start the presentation already. And the topic we have today is intellectual property enforcement. So similar to the definition of our mentor, my group slide had said that intellectual property enforcement is taking legal action, against infringement that has been done, right? So that's infringement on a person's intellectual property rights. And this intellectual property right can either be trademark, copyright, industrial design. It can also be like trade secrets. For example, my company, I have a business in, but let's just use that as an example. You may like to global. So I deal with fashion, and maybe I see another company that takes my business secret or my trade secret. I can actually say, oh, I want to take legal action against them. So that's like the summary of what intellectual property enforcement is. It's just taking taking action to prevent your right from being infringed upon, or getting remedy if your rights have already been infringed upon. So with that being said, we're actually going to look at the importance of this intellectual property enforcement, especially to owners, that's the people who own this intellectual property. Number one, it's important because it's going to advance or encourage innovation and creativity. If we have intellectual property enforcement on the high, and it's actually going to encourage innovation and then creativity, because people will not just want to steal somebody's own, because they know that if they do that, actions are going to be taken against them. So they would rather sit and get their own original stuff out there. So that's one. And number two, the owners of this intellectual property are going to suffer damage. They are going to suffer their rights being infringed upon if we don't have this enforcement mechanism in place. So that's number two. And then number three, sorry. For number three, I'm trying to recall it. So, okay, so for number three, I'll just speak from what I had gathered from whatever I had read. So for number three, it's going to prevent, it's going to cause fairness and equity in the marketplace, in the industry, and in the world at large. Easier.
Hello, Sylvia, can you hear us? It seems the network seems to be a pandemic. Network challenge seems to be a pandemic in class today. We sincerely apologize for all the issues that multiple of us are having. Please, Sylvia, if you can hear us, please, we'll still be taking your presentation. Oh, okay. We have lost her for now. I don't know, we'll be getting back to her soon. But please, if we have the presenter for the fan in class, please let's take your presentation. We are waiting for you guys. Okay, I can see Sylvia, I can see you're back with us in class. Can you hear me? Hello, Sylvia, can you hear me?
I can hear you now.
Yes, you went off completely.
Oh, wow. I think the network is very bad. I apologize for that. Sir, can you hear me?
Please, yes, can I share your screen on your behalf while you make your presentation?
Is
We can't really hear you. Your voice isn't so clear.
Sir, can you hear me now?
Much better.
Okay. So should I start from the beginning?
No, please, can you move on to from where you stopped last so that we'll save time?
Okay. So I'm online enforcement mechanisms, and I was on point number 1, which is custom and border seizures. States that they are agencies that are responsible to, and these agencies standard organization of Nigeria. Yeah, so for
Hello, Sylvia. We can't
seizures,
hear you
they
anymore.
can just dogs or goods that a particular
Wow, I think um, the I don't
Um,
know how
can I
to.
step? Good evening. Can I step in for her? But I can't share my slides if that's possible. So we'll quickly round up with group 2.
Oh, all right. Thank you, Linda. Yes, you can step in for her. Give me a minute. Let me put up your slides. All right. Please go ahead, Sylvia. Please try as much as possible to make your presentation as fast as you can. Linda, can you hear me? Can you see my screen?
Okay, yes, please. Can you take it to? I think she was at physical enforcement, or can I control it?
Please go ahead. I think I'm there.
Okay, yes. So when it comes to physical enforcement mechanisms, we decided to use Nigeria as an example. So we have our law enforcement agencies that are actually authorized to carry out raids on markets, warehouses, and also manufacturing sites. And a typical example is market rates at markets like Alaba Market and Onitsha markets that are actually known for counterfeit hubs. And then another form of enforcement is a court order that is restraining a party, a guilty party, from continuing with the act of infringement. So we get when you get this court order, like one of the mentors was saying earlier, they will ask for them to cease and desist from continuing the act of infringement. And then there are also options of criminal prosecution. So you can ask for the right holders can sue for damages and also delivery of those infringing goods if they are actually physical items. So the legal frameworks that are guiding enforcement of intellectual property are Trademark Act, Copyright Act, Patent and Designs Act, and also the Federal High Court, which is the court that has exclusive jurisdiction over IP matters. So the next slide, please, is that's challenges of online and IP enforcement. Please can you move to the next slide? Okay, thank you. So when it comes to online intellectual property enforcement, you know that the nature will be complicated because it's digital, it's in digital form, and so we have issues of jurisdiction. It's because it could be in another country from where you're at. So the IP rights are now territorial. So for example, uploading pirated content, and when you trace the person is not in your jurisdiction, it's in another country or continent entirely, and probably their laws also are not going to be helpful in you pursuing to get your IP rights protected and all that. So there's issue of jurisdiction, and then cost and resources also. So it's it's not easy also if you're not financially stable enough to pursue and enforce your digital right, because there has to be investigation, monitoring, tracking, and all of that. So for small upcoming creators and business owners, that's not going to be easy. And we have a lot other like destruction and storage of goods, corruption with enforcement officers, weak penalties, and then repeat of offenders. For example, there's let's say these sites that usually upload pirated movies and music. So you'll notice that they'll bring that side down. These persons will come back and keep doing the same thing. So those are the challenges we face. So we have a case study of next slide, please. Interpol and WCO operation. That's a case study. Okay, yes, we have WICO is World Custom Organization Initiative that actually targets counterfeit products. So the IP right that was infringed were counterfeit branding of the food. It was actually the branding, and so the enforcement action that was taken were custom seizures of those branded items from the market and warehouse, and then arrests were made and criminal proceedings were initiated in multiple jurisdictions. Please let's move to the next slide. Sorry, the next slide, please. Not this one, the next one. Okay, so yes, and further challenges of online enforcement specifically, we have anonymity, where infringers use pseudonyms, they use VPNs and anonymous hosting sites. So it's actually difficult to track them or the people behind those sites. You also have the issues of offshore servers where the infringing content is hosted on a jurisdiction with lax and then relaxed IP enforcement, which is actually out of reach for Nigerian or your country's courts to pursue. And then we have like the issue of when it's done in developing countries with weak enforcement infrastructure, especially in developing countries. Nigeria is not an exemption actually. So Nigeria and Africa countries generally they lack proper technical and okay, let's keep it at technical to actually pursue online infringers. It's going to cost the creative a lot of money to pursue. So that content or whatever could actually go viral before you can do anything or ask for a takedown. So next slide, please. A case study I'd like to highlight is WIPO UDRP and MTN Group Limited against Cyber Squatter, which is a domain dispute. So MTN Group, a Pan-African telecom giant, filed a UDRP complaint with WIPO over a domain name registered by a third party that incorporated a MTN trademark, and the registrant had no legitimate interest in the domain and was actually using it to divert traffic and to extort right holders. So WIPO panel ordered the transfer of domain to MTN. So that's an example, a case study. Next slide, please. So we have arbitrability of IP disputes. When it comes to enforcement, arbitration is also an option, and then disputes actually refers to whether a particular IP arbitrability of IP dispute. It means that is a particular IP, can it be resolved through arbitration rather through the traditional court litigation, which can take time and be exhausting. So arbitration is an alternative dispute resolution method where an independent third party, the arbitrator, comes in and then makes a binding decision. So there are certain criteria that should be in place before an IP dispute is arbitrable. Example, consent of parties, subject matter. If the dispute concerns issues that can be settled outside court system, then yes, you can go ahead and settle it with arbitration. We also have public policy and other factors. And please, next slide. So one of the reasons why people go for arbitration when it comes to IP infringement is that because of next slide, please. Yes, thank you. Is because of the speed and efficiency that comes with it. It can be faster rather than going to court system, and then confidentiality. You know, when your matter is in court, it becomes public, and and then you're talking about intellectual property. Maybe there are certain things you're still trying to keep, like trade secret and all that. So yeah, arbitration is your best option. And then you also have the expertise of arbitrators, and then finality and limited appeal. Binding decisions. Arbitration usually results in a final and binding decisions. And then we have flexibility, cost effectiveness, preservation of relationships, and because litigation can actually get a little bit, should I say, dirty or something. And then enforceability of agreements. Then next slide, please. Sorry, how much time do I still have? I feel like I've spoken over.
Please round up in 3 minutes.
Okay. Okay, yeah, so generally the types of IP disputes that can be arbitrated are licensing disputes, royalty disputes, franchise agreements, IP assignments, and disputes. So we actually have WIPO Arbitration and Mediation Center. It specializes in intellectual property and technology disputes. It offers arbitration, mediation, and procedures with neutral IP expert arbitrators in over 50 national IP officers. They refer disputes to um, WIPO for resolution. So, in conclusion, when it comes to IP enforcement, we have two ways you can go about it. You can go through normal litigation, and then you can go through arbitration, but you just have to get your facts right to be sure of what is arbitrable and what is not arbitrable. So thank you very much for listening. That'll be all.
All right, thank you very much, Linda, for stepping in to make presentation on behalf of your group, even though you were not originally the designated presenter. So well done to you for doing that. Well done to you for doing that. We don't know if the presenter for group one is now ready. Sorry. All right, so please, if group one is ready, I think the group presenter is complaining about network. Um, So we don't really waste so much time. Mr. Boluwatife, please, we want to get back to you. Unfortunately, network has been super difficult to manage in the session today. We sincerely apologize that we had to deal with all of this. To all the mentors also who are present for class, we sincerely apologize that we had to deal with all of this. So Mr. Boluwatife, we just want to get back to you. You have seen the presentation prior to now. We want to see if we could get maybe some feedback on what the mentees did in their work, some feedback to the presentation and presentation styles, if there's anything you would like them to adjust, and maybe any other thing you would like to mention as pertain what you initially started sharing, and then we'll take questions. Are you with us, sir?
All right, thank you so much. Am I audible?
Yes, sir, we can hear you.
Okay, I really do not have any comments regarding the presentations. I had the opportunity to go through sparingly the presentation, not in detail, I must say, the presentation of groups one and two. I must first commend you for the work you have done. Initially, when I went to the presentations this morning, I had reached out to Sophie or Sophie, I'm not sure which of that, one of the members of the organizers, asking whether it was necessary for the mentor to actually prepare a presentation, because so just this morning I had the time to prepare my own presentation too. So I commend you for what you have done. You've done very well. I also recommend that you kindly go through the presentation I prepared. You may want to, I've sent it already during the time when the second presenter will add the floor. So you want to go through my presentation specifically. I'm happy to answer questions if you have any for me. And just to mention to you that we are all in the same space at the moment, and you may want to start looking more into digital infringement. I think that's where the gold mine for dispute resolution is at the moment. Aside from, although there are several other works that can be done in the IP space, but dispute resolution in the digital space now is really a big one, and you may want to start building a practice around that area, aside other practice focus areas in IP. That would be all I would say. Thank you so much.
All right, thank you so much, Mr. Abdulwati, for your feedback. All right, so please, if there are questions for our mentors, we'll be taking them. If you have any question you would like to ask in the session, please do so by raising your hand or through the chat box. You can send your questions in so that we would round up the session as soon as possible. Yeah. So please, if you have any questions, let's take questions. Let's take questions. Let's take your questions. Um, Please, let's take questions if we have any. So no one with any question. We are talking IP restriction, infringement, and enforcement. I'm sure someone here must have encountered a case or a case or two where they seemed not to understand what was going on. And I think even Mr. Emmanuel, while he was present, I guess unfortunately because of his network, he couldn't stay true to the end. He raised something very, very important around infringement, the case study he started dealing with. We don't know if Mr. Bulu Atsupe, you'd like to share your thoughts on that. If I can bring it up again, I would like to get your perspective on it. Okay, so I would really ask the question once again, and I just want to really hear your perspective on it, sir. Uh, so the so the question goes like this. It's an icebreaker question that Mr. Emmanuel sent in. So the question goes like this. A small-time artist records a song in his room and uploads it online. The bigger artist discovers it, recreates the sound. A bigger artist discovers it, recreates the sound with better production and releases it. The new version goes viral and generates millions. The original artist comes out publicly. That is my sound. That is my song. So the questions here are: has infringement actually occurred? The second question is: can sound or style be legally owned? And the third one is: who is entitled to the revenue?
Sorry, can you take the questions one? Can I answer the questions one after the other? You read the question then answer.
All right, sir. Please, you can take them one after the other. So the first question is: as regards the case study, has infringement actually occurred?
Yes, please, you may want to, yes, infringement has occurred. You may want to refer to the Nigerian Copyright Act, specifically on sound recordings. Sound recordings are protected by copyright. So if somebody else takes, whether you are a small man or you are a big man, whatever you are, takes your work and reproduces same, of course, unless the works are different. If he has reproduced it, yes, it is an infringement.
So the second question, I think you did answer that in your presentation, but we still want to hear you maybe share your thoughts on it. Can sound or style be legally owned?
I didn't get that.
The question is, can sound or style be legally owned?
Definitely, definitely, definitely. Can sound be
All right,
legally owned?
yes, sir.
Yes.
All right, so the last question is, okay, who then is entitled to revenue based off of the case?
Who then is entitled to revenue? Revenue in what regard?
So the revenue based off of the artist, the original artist who made the song, or the bigger artist who then rebranded the song, and then maybe using better production release the song.
Of course, the earlier artist has every right to the revenue. However, you see, one of the reasons I feel laid back sometimes while answering um, hypothetical questions is because you can't really determine the extent, and I'll tell you why. But the answer to your question is yes, the earlier person has the right to the revenue. However, and of course, let me even go further with that. He has a right to the revenue. You could say the big producer or the big musician or artist should give an account for profit. So the account for profit will be what will determine what the small, sorry, I'm using that in quotes now, the small artist would get. Now, I was trying to address the reason I get laid back a bit for hypothetical questions. That's because in some instances, if you look at the Copyright Act says maybe in section 4 or thereabout, I think that's the old act. I'm not sure what section it is in the new act now. It says something around that you have used somebody's work, but you have worked more on it, does not necessarily infer that your later work does not enjoy copyright protection. So in an instance where the later work enjoys copyright protection, now the question would now be, can the earlier artist, can he enjoy the revenue derived therefrom? So I really will not be able to, you will not be able to answer that question. I know it may rub off on the question you have asked me. If one does not listen practically to what exactly the issues are, listen practically to both songs, I mean. So I think that's about it.
All right, thank you very much, sir. We sincerely do appreciate your feedback to those questions. So I want to assume that in the absence of any question, it is safe to say we have at least been able to cover quite a lot as it regards to IP restriction, infringement, and enforcement. Mr. Bolu, what if they have sent his presentation? We'll be sending it to your group. Please make sure to go through it. I'm sure, yeah, I saw in his slides he cited some of the laws that covers for it, some case studies, and other very, very important things that we would find useful as a resource base, under this particular topic. So thank you once again, sir. We sincerely do appreciate everything and the time you took to prepare your slides and to ensure that you shared it with us in today's session. All right. So with that, we've come to the end of today's class. Please, for the mentees, do not forget to fill your registration and to share what you have learned. Also, you can follow Mr. Boluwatife. Please, I don't know if it's going to be possible for you to drop your handle, maybe your link to your LinkedIn account or your Instagram, so that our students who want to keep up with what you are doing within the space will be able to follow you through. Or you can send it straight to us and then we forward it to them in their group. Yeah. So thank you so much once again, Mr. Boluwatife.
Yeah, you're welcome. I would send my LinkedIn and my Instagram to Sophia or Sophia. I'm not sure which of those.
All right. So once we get it through her, we will do well to forward it to it. Thank you, everyone.
That's
Please good night and enjoy the rest of your evening.